We'll begin the oral argument today with the Rule 20 oral argument cases. The first case is In Re SL, docket number 20-0015. This is an appeal from the Circuit Court of Roane County, West Virginia. And although Justice Workman is not present here in the courtroom today, she will be listening to the oral arguments and participating in this case for its decision and opinion. I would remind you that each side has 20 minutes to present your oral argument, and in this case, the respondents will be splitting that 20 minutes. So the petitioner, you may proceed.
Before you do so, if I could just, we are, have been wearing our masks, and we are...
Sorry, Chief, I took mine off.
Okay. We do have our barriers here, as well as being more than 6 feet apart, so we will allow the justices to remove the masks in order to take part in the discussion today, but we just continue to observe the other precautions and social distancing. You may proceed.
Your Honors, I believe I was called here for the sole purpose of explaining why I had not filed the timely appeal regarding this case, and instead of waiting until after the motion for visits was denied. The reason for that was because my client originally did not want to file an appeal. She just wanted visits. After the judge denied the motion for the visits, she did at that time decide she wanted to appeal. I was in error in not filing a motion to file a late appeal at that point. And so I have filed a motion for leave to file a late appeal. Yes, I filed it because I put it in the box. So that's my reasoning behind it.
All right. Are there any questions?
Let me make sure so you filed a motion to file a late appeal, but you say that your client decided originally not to file an appeal from the disposition order. That was a voluntary choice, chose not to, but at some later point changed her mind and directed you to file an appeal, and you did so to the post-termination visitation order. So the only appeal was to the post-termination, but in the post-termination order, you're using that as the jumping off point to try to go back and have the court review the original dispositional decision.
That's correct, Judge, because at that point I thought that it was important for the court to understand the entire case.
But other than just a change of mind by your client at a later date, any other basis upon which we should be considering the dispositional order?
Well, I was also concerned at that time that it was would be an interlocutory appeal, since she did want to wait until afterwards, and she did not want to appeal in the beginning. So I wanted to abide by her wishes. And then when she did want to appeal, I think this court has directed that I am required to file an appeal if she requests one. So that was the reason for it.
Thank you.
Just a question about the impact that would be perhaps in terms of setting precedent of allowing the filing of a motion for post-termination visitation to allow that to extend the statute of limitations, or not statute of limitations, but the deadline for the, would that not extend or potentially extend each of these cases and allow permanency to be delayed in other cases if we follow that route?
It could, Judge, but I believe that this may be the perfect opportunity for this court to make it clear to all of us that the way that it should be done, because in all my research, I have not found anything that, relating to the interlocutory appeal or to the appeals that are late. I've seen stuff, some stuff in criminal cases, but that's a little bit different than this. So I think this is a good opportunity for the court to explain its position regarding that. And I am requesting that the court grant my motion to file the late appeal.
Did your client have visitation prior to the termination of her rights? I mean, what can you kind of give me a...
It was supervised visits. Her child is a special needs child, and she had supervised visits with her.
Do you know when the last time she had visitation with her?
It was just before the termination.
All right. All right. Are there any other questions? If not, thank you. You have
Thank
an
you.
opportunity for a rebuttal. Hear from the respondents, please.
Apologies.
I'm sorry.
That'll play well on YouTube.
Part of
Part of our
everybody's
precautions,
process.
yeah.
Exactly,
That's right.
we're making it work.
Live and learn.
Good morning, and may it please the court. I'm Lindsay C. on behalf of the department. With understanding for the reasons that led to in the motion to file the late appeal, the only decision that is properly on review for this court today is the circuit court's decision to deny post-termination visitation between the petitioner and SL. That is the clear result under this court's rules and also under existing decisions. Where the department does agree with petitioner, however, is that this is a good opportunity to clarify the precedent that governs late filed appeals and whether these are jurisdictional issues or not, or ones where equitable considerations could be taken into account. Here we have a situation where it's very clear that the appeal of the disposition order itself was both filed out of time and perfected past the 60-day deadline. And there's no exceptions under the rules and existing case law to excuse that defect, even though there were multiple final appeals in this case. So unless this court chooses this opportunity to clarify the precedent that does govern situations like these and decides that this is the appropriate case to exercise its discretion, the appropriate disposition is to dismiss the portions of the appeal that relate to the termination order and then to affirm the circuit court's decision to deny post-termination visitation. There's really no question about the timing in this case. Here we have an appeal from the visitation order that was timely filed within the 30 days. However, that appeal also tried to bring in the substance of the termination order that had been entered 69 days earlier. The petitioner's brief was also filed past the 60-day period after the termination order, so there's no question that it was both untimely and not perfected. So the issues we have here is, are there any exceptions in the rules or in decisions that might allow that? And the answer is no, at least again under existing law. The rule that petitioner relies on in the motion she filed yesterday is Rule 11F. And that one does have circumstances to allow for a late filing of a brief or a late filing of a notice of appeal. But under its plain text, it doesn't resolve this case where we have both of those errors. If there's a request to extend the deadline to perfect an appeal, that can be granted, but only if the notice of appeal was properly and timely filed, which isn't true here. And if a notice of appeal needs to be excused, the rule says that can happen in extraordinary circumstances, but again, only if the motion is filed on or before the date that the brief was supposed to be perfected. And here we have a motion that was filed 8 months later. So that rule simply doesn't offer relief. The department does agree that there might be other mechanisms under the rule to allow this. For instance, such as the general rule in 39B to allow the enlargement of time for good cause shown. But the court would have to resolve first whether there's a jurisdictional defect in this case. Because here we have a circumstance where the petitioner filed her brief after the 60-day period for perfecting an abuse and neglect appeal, but before the 4-month period the statute sets for perfecting an appeal. So in that case, there's a question whether the court can excuse this delay with the difference between the 60 days and the 4 months. In a series of memorandum decisions, this court has explained that the 60-day period is jurisdictional. But the department would not object to the court revisiting this line of cases. And there's several reasons for that. The first is those memorandum decisions, of course, they're not syllabus points, precedential in that sense, but they also rely on cases that dealt with the statutory 4-month period. So we don't have a circumstance where this court has squarely addressed whether the 60 days that are in the rules but not statute is jurisdictional in the way that the 4-month period is. This court has also, on occasion, exercised discretion to entertain appeals that are filed beyond the 60 days but before the 4 months. Again, the court hasn't squarely addressed the issue, but those decisions would imply that the court has jurisdiction in those cases. And the department would agree that's the right result. Usually the line between a jurisdictional rule and a claims processing rule is whether the deadline comes from the statute. The United States Supreme Court explained this in 2017 in Hamer versus Neighborhood Services. And there it held this line between deadlines that come from statutes and those that come from the rules. And that line makes sense, too. There's nothing in West Virginia's understanding of the separation of powers or jurisdiction that would call for a different result. The legislature does have the authority to limit jurisdiction of the court in certain areas, and so in that case, if we have a statute, it makes sense that the court would be without jurisdiction if a brief is filed late. But in a case like this, it's the court's own rules that set the 60 days. There's very good reasons for that, and the court is under no obligation to depart from it, but the court also isn't disabled from departing from it if the circumstances warrant it. So the department would urge the court to resolve this issue. This is an area where clarity matters a lot for all of the litigants, and it matters for fairness to know whether or not an appeal could be properly considered. So the department does ask the court to consider it in this case. If the court did clarify that the 60 days is not jurisdictional, then it would have the ability to entertain this appeal in its discretion. And so it certainly wouldn't be automatic. The court wouldn't be erasing the 60-day limit, but it would be saying that there is an ability in appropriate circumstances, good cause or extraordinary circumstances, depending on the rule, to depart from that limit. The second issue, where it would be very helpful for the court to clarify precedent, is that in cases like this, where there are multiple final orders in a case, that simply isn't a reason to restart the appellate clock for a first order in an appeal, first order in a case, where the party could have taken an appeal but did not. Now, of course, there's a general rule that when you have a final appeal, it also gives the ability for a party to appeal all non-final orders that came before, discovery orders, motions to dismiss. But there's no precedent going the other way. If you have one final order the party could have appealed, you can't bootstrap that appeal into an appeal from a later final order. And here we have both a disposition order and a later order that are both final. There's no question that a notice of appeal could have been taken from both of those. And the fact that petitioner chose not to appeal the first order, there's not another opportunity to restart that clock later on. This court has reached this conclusion in a number of different contexts. In a DMV case decided in 2007, for instance, a party didn't appeal a final order, but instead asked the circuit court to clarify that order. The circuit court did a number of months later, and the party tried to appeal the substance of the first order in an appeal from the clarification order. And this court held that that's not proper. The issues in the first order were not on appeal. Because there's no briefing on this, I will give a citation for it. That is Moten versus Stump, 220 West Virginia, 652, 648 Southeast 2D, 639, 2007. There's a similar holding in a family court decision where the court was looking at issues of custody and visitation and also reimbursement for medical expenses. And there the court was clear that only the first set of issues were properly before the court because the reimbursement claims came from final orders that had been entered at an earlier stage in the proceeding. So again, this court was clear if the party wanted to challenge the substance of those earlier orders, then it had a duty to file a notice of appeal at that time and could not retroactively bring them in. And the citation to that case is Mary R. versus Billy D., 219 West Virginia, 520, 637 Southeast 2D, 618, 2006. Now, the court has not squarely held this rule in the abuse and neglect context, but there's no reason to reach a different result here. And in fact, the rationale for the rule is even stronger in this context. The reason we have this rule is the importance of finality in court judgment, so all parties know what their rights and responsibilities are, and we don't have an indefinite appeal period. Here, that rationale is particularly strong because the key interest in abuse and neglect cases is the best interest of the child, and permanency for the child in these cases cannot be resolved until any appeals that are taken from final orders are finally resolved. So if we have an order that allows for exceptions outside of very clearly delineated circumstances, then we undermine that interest in finality. Now here, we have a circumstance where the delay was only a matter of a few weeks, and it doesn't appear that there was much prejudice to the child, where adoption proceedings are still underway and the child is doing well with her foster family. But that's not always going to be the case. So if this court were to relax the rule about when a final appeal can be brought into a second appeal, we could have circumstances where a motion is brought months or potentially years later. And this isn't hypothetical. This was a Disposition 6 termination order, but the statute also allows for a Disposition 5, which gives custody to the department. And that disposition specifically anticipates that there might be a motion for changed circumstances, perhaps well in the future, that might warrant the parent retaining custody. We simply don't want a circumstance where an appeal from that order months or years later could reopen the substance of the underlying proceedings. So the rationale for this case is even stronger. And finally, I would briefly mention that to the extent there are fairness concerns to the parent in situations like this court has not hesitated to apply procedural and jurisdictional bars where they lead to harsh results, even in contexts like criminal appeals, where the interests are just as or even more compelling. I will note, however, that a similarly situated criminal defendant might have a potential avenue of an ineffective assistance of counsel claim. As this court is well aware, this court has not resolved whether West Virginia law recognizes a right to ineffective assistance in this context. The department is not asking the court to reach it here. It's not before the court. We don't have the right record. The department is certainly not making any representations about the quality of counsel in this case. But it is important to look towards, to look for the right opportunity in the future to take up this issue, to make sure that there is an appropriate balance between finality and the interest of fairness to all of the parties involved. The department urged the court to take up this issue in a case last year, and we would continue to urge the court at the next appropriate opportunity to resolve that important question. But for this case, unless the court decides that the rules are not jurisdictional and exercises its discretion to reach the merits, the department will respectfully ask that the court dismiss the portions of the appeal relating to termination and affirm the portions of the appeal relating to visitation, as there were no error from the circuit court. Thank you, Your Honors.
Thank you. Can I hear from the guardian?
May it please the court, Ryan Ruth on behalf of the child. I think Chief Justice raised the concern that I have is achieving permanency for these children. You can't, although it wasn't all that late in this case, a deadline is a deadline, and to be honest, in this case, once the deadline passed, I had informed the foster family of that. They were more excited about getting to the process of the appeal at that point, and then to later have this motion filed. And then looking back at it, even last night, looking at the deadlines, I think the last time counsel for the petitioner could have filed a notice of appeal timely would have been November 29th of 2019. And I'm not sure if it was ironic or just good timing or whatever, but the motion for post-termination visits was filed on the same day. So it's a little bit suggestive that maybe knew a timeline was passing that day, and then later tried to fix the deadline problem by appealing the post-termination visitation, and then also using that as counsel said, bootstrapping that to discuss the termination. With all that, I agree with the department. The only thing properly before this court is the question of whether the lower court was proper in denying the post-termination visitation. I don't believe the termination issue is proper before the court. Even if it is, I think the court was well within its right, did not err, did not abuse its discretion. To me, it was a clear case of termination. With respect to the child, just to give an update on the child, 8 years old, getting ready to enter the second grade. as counsel for the petitioner pointed out, is a special needs child. As of right now, she really doesn't have the skills of second grader. She has problems just counting from 1 to 10, reciting the alphabet without any help. The foster family and myself have, well, with all the options you have for school now, we have agreed that her going 5 days a week would be the best, considering her IEP and other issues she has going on. Her pediatrician just recently referred her to a neurologist that specializes in cognitive functioning to see if there's any issue there. That's really all I have to update the court on. She has been in the same KVC foster placement since May of 2019, so we would like to get permanency achieved for her through adoption by the current placement.
All right. Any questions for the guardian ad litem? All right. No, thank you. Now, if the petitioner has any rebuttal?
The court made it very clear in all of its communication with us that we were not arguing the merits of this case. We were only arguing whether the court can consider a late appeal regarding the termination. I still believe that this is a good opportunity for the court to clarify this, because it was not clear to me in my research that it was a late appeal to start with. And so that all issues had not been resolved in that case. Yes, there was a termination order, but all issues had not been resolved in that case. And therefore, I would request that the court certainly consider whether visits are appropriate, and also grant my motion to file a late appeal on the other issues.
If I could just ask you, you said it was not clear that it was late. Under Rule 49, there's a 30-day period to file the appeal and then 60 days to perfect it. And so do you believe the confusion was that you felt like that you had the 60 days, or do you just feel like that the confusion was that once you filed the petition or the appeal of the denial of the post-termination visitation, that also allowed you to raise the termination question? So where did the confusion come from?
Yes, Your Honor, that was my confusion, was that it was my belief, and I couldn't find any different in the research, that because the issue of visitation was timely, that appeal, then to me, I didn't see any reason why I couldn't raise the issue of the termination as well.
Okay. All right. Are there any other questions? If not, thank you very much. This case will be submitted.
Thank you.
And congratulations on being the first advocates here in our new world of masks and microphone covers and plexiglass. We appreciate.
I was telling them that I told Judge Goodwin one time that if it wasn't for the honor of being tarred and feathered, I'd just soon avoid it. I think that's a Mark Twain quote.
Thank you all. Have a great day.
My boys play hockey. This kind of reminds me of the rink a little bit.
They probably need a lot more barriers in hockey, don't they?
Somebody said we looked like the starting gate at the Kentucky Derby. Hutch has the pole position.
Yeah. That's right. That's right. Computer. Every time I bring that in here, it'll just go off or something. just hit delete. I don't know why it's doing that.
Okay, the second case for oral argument today is also being argued under Rule 20. In re HL and ML, docket number 200052. And I will let you know that although Justice Workman is not here in the courtroom today, she is viewing and listening and will participate in the decision and opinion in this case. I'll remind you that each side has 20 minutes to present your argument, and since there are two counsel for the respondents, you will divide that 20 minutes between you. Counsel for the petitioner, you may proceed.
Justices, may I slide my mask down while I speak?
You may.
May it please the court, my name is David Fuelhart, and I'm here representing the petitioner in this matter, the mother of the children. We're here today from a case arising out of Randolph County, and my argument consists of two assignments of error. The first assignment of error essentially contains three separate points. As the mother was adjudicated abusive and neglectful based on three separate allegations contained in the petition. The first is the use of controlled substances. We believe that the state failed to prove by clear and convincing evidence any of the allegations contained in the petition against her. As to the use of controlled substances, in the record from the adjudication hearing, the state witnesses admitted that the mother was screening negative for controlled substances prior to the adjudication hearing. They also admitted that there was no evidence the mother ever used controlled substances around the children. It looks like what the state used to attempt to argue that there was clear and convincing evidence of the use of controlled substances is testimony from the guardian ad litem from a previous family court proceeding that the mother didn't comply with certain drug screening requirements, things like that. There was one prior positive drug screen, it appears, but that was a single drug screen in a family court matter that occurred sometime before the lower court proceedings that bring us here today. Additionally, the state did not prove or present any kind of evidence that this alleged drug use, if any, impacted the mother's ability to parent. There was no evidence she used or was ever under the influence of controlled substances around her children. So we believe that the state failed to prove by clear and convincing evidence the use of controlled substances sufficient enough to merit an adjudication. The second issue that was raised by the state in the petition was domestic violence. This one is pretty clear in the petitioner's opinion that there was not clear and convincing evidence that the mother engaged in any domestic violence. In fact, through testimony from, I believe, the guardian ad litem or another state witness, the eldest child in this case stated that the mother was the victim of domestic violence from the father, but stated that the child had never seen the mother commit any domestic violence. In fact, there was no evidence that the mother committed any domestic violence towards the father or the children. So we believe that the state failed to meet its burden of clear and convincing evidence that the mother actually committed domestic violence. And third, and I believe most importantly, were allegations that the mother failed to protect the children. There was pretty clear evidence presented that the father did engage in domestic violence against the mother. The mother didn't deny that, and that although the domestic violence was committed in front of the children, the mother did not immediately remove the children from that situation, and based upon that, the court found that she failed to protect the children and an adjudication was made. Here, I would argue that the mother would be considered and meet the definition of a battered parent under West Virginia Code 49.12012, which defines a battered parent as a respondent parent, guardian, or other custodian who has been adjudicated by the court to not have condoned the abuse and neglect and has not been able to stop the abuse and neglect of the child due to being the victim of domestic violence, as domestic violence is defined by the code. And when you look at the definition of domestic violence and the allegations in this case, it's clear that the mother was the victim of domestic violence. There were threats, verbal threats, there was physical violence, and in fact, the mother at one point did take steps, remove the children from the home, filed for divorce from the father, filed a domestic violence protective order, and did take the steps necessary to protect her children. The state's argument centers around the fact that this was not done sooner, but I think that this is where the definition of a battered parent comes into play. The mother, through her testimony, admitted or stated that she felt she was manipulated by the father at the adjudication hearing, that she was in fear of the father, of what might happen if she removed the children from the home, and that was the reason that she did not act sooner, that she actually thought, as a mother, that it would be more dangerous because of the father's attitude and previous behaviors to remove the children from that situation in fear of what the father might do. What's less clear, and what we're arguing today, is exactly what the court should have done after it would have found that the mother was a battered parent. We would argue that the petition should have been dismissed as to her, and that services should have been put in place for the mother to ensure that she understands the dangers of being in a domestically violent relationship, and to ensure that these children are not exposed to that situation again. Alternatively, if the court did not feel that a dismissal was warranted, the court could have still adjudicated her, and instead of, as a battered parent, as provided by the West Virginia Code I cited before, the court still could have adjudicated her as an individual who is a battered parent, there was domestic violence in the home, and then provided those services, whether it be through a typical improvement period or something along those lines. But surely, the mother believes that that would have been a more appropriate disposition in this case than terminating her parental rights. Because when you look at the totality of the evidence, or the sufficiency of the evidence, with the clear and convincing standard, as I stated before, it doesn't appear that the state proved the use of controlled substances sufficiently. Certainly it doesn't appear that they proved that the mother engaged in any kind of domestic violence herself. And as to the failure to protect the children, the argument that she was a battered parent under the West Virginia Code, we believe, is sound, and that the court should have taken steps short of terminating her parental rights to protect those children, because by educating her, by assisting her with counseling, that would have been a less drastic disposition, as the West Virginia legislature has laid out the 6 different dispositions. Obviously, termination of parental rights is the least favored disposition, and under these circumstances, it appears that there were steps and measures that could have been taken by the lower court short of terminating parental rights because of the mother's status as a battered parent.
So we're here on Rule 20 largely to take a look at this battered parent or battered spouse exception, if you want to call it that roughly. But my question is, what about the allegations that your client permitted her spouse to have contact with the children after a domestic violence order was in place?
Your Honor, our position would be that again, is another symptom of being a battered spouse. A battered parent, I guess it's defined as a battered parent, but a battered parent is an individual who is so emotionally, psychologically manipulated and worn down that she did take those steps of getting the domestic violence order in place. However, that emotional and psychological state of being a battered person doesn't just cease, even though you took those measures. It's a long-term process to overcome what was done to her. And was that a mistake to allow that contact? Certainly, but Our position is that was a symptom of her status as a battered parent, and that if the lower court would have maybe provided services to her to show her that that is improper, or again, to guide her through getting over the circumstances and actions that she went through, that may have been able to be prevented.
Do you think that's one of the questions of the law where the definition and statute of a battered parent suggests inherently that the person is non-abusing? And you raised to Justice Walker's question, the effect of being battered could cause certain circumstances and conduct to occur. Is that a problem with the statutory definition, that if any abuse occurs, you lose your opportunity to be deemed a battered parent?
I don't, when you look at this definition, I don't believe it's a problem due to the language that says that the battered or respondent parent, the battered parent, has not condoned the abuse and neglect and has not been able to stop the abuse and neglect. I would argue that not being able to stop the abuse and neglect, in this case, even by allowing contact or whatever the circumstances may be, if the battered parent is the abuser under the circumstances that you mentioned, that would still fall under this definition, because the mental state that she's in, she's still not condoning it, although she is the one making those actions. You know, the mental experiences she's been through has almost made it impossible for her to, I'm trying to analogize it to consent. If you look at another case where consent becomes impossible, where an individual is of a certain mental state, I would argue that this is similar in that because of the mental state, it's impossible for her to commit the abuse or neglect, because it all stems from what was done to her by another individual. And I think because of that, the definition can still stand.
And the second question is, obviously the lower court's order was silent with regard to any findings of facts or statements relating to battered parent, although clearly the court on the record made reference to it orally. What in the statute or our case law would require the court, given the fact that it was an issue and the failure to make any reference to it in the court's order, raise concern?
Your Honor, could you rephrase? I'm not sure I exactly understand
the circuit
question.
Court's order did not find battered parent, even though clearly evidence was presented and the court orally made a comment about it. The fact that the order made no findings of fact or no determination regarding battered parent, is that in and of itself obviously part of the area you're suggesting, but what is the statutory or case law that the court had an obligation to address that issue, and its failure to do so is the basis for your finding of suggestion of error?
Again, Your Honor, I do believe that is covered by the definition in West Virginia Code 49.12012. It says a respondent parent who has been adjudicated by the court to not have condoned the domestic. Without repeating myself again, I believe that the lower court, through this definition, has the obligation to adjudicate an individual as a battered parent in the circumstances where they have not condoned the abuse and neglect, nor been able to stop that abuse and neglect, which I think sufficient evidence was presented at the lower court level to meet that definition, and therefore she should have been adjudicated as such with, I guess there's no real guidance in the definition as to what findings of fact are necessary, other than we believe that the mother did not condone this abuse and neglect. She was not able to stop the abuse and neglect. It was perpetrated by the same individual, the father, and therefore, based under this definition, there's been sufficient evidence for an adjudication as a battered parent. So I think, again, the statute can be interpreted to require an adjudication when the definition is met.
Let me ask you a question. I'm going to get away a little bit from the battered parent issue, but as I read this case, the decision was made to terminate her based on, as I understand it, three things. First thing is she tested positive one time in May of the year immediately preceding the filing. I guess it was, in fact, it was within the same month as the abuse and neglect petition was filed. I think she tested positive for methamphetamines on May 19th, and the petition was filed on May 30th. Does that sound about right? Well, let's assume that that's right. I don't want you to have to go digging through your notes. All right. So she tested, they said she tested positive, and the department took the position. She denied that, said there was no way that she should have tested positive. In fact, the urine screen was negative. They sent it off to a lab. The lab says, oops, we found something in there that indicates that she took methamphetamine. She continued to deny that. So the department says, she denies that she has a drug problem, therefore we can't create a family case plan that takes care of that because she refuses to admit that she has a drug problem, right? That's the first thing.
I'm following, Your Honor.
All right, you agree with that scenario?
I agree that that's the...
My reading is the department says we can't, she doesn't admit she has a drug problem, therefore she can't, under the case law, she can't have an improvement period because she refuses to admit.
I agree that's the department's position.
All right, the second issue is they say, well, wait a minute, she's not a battered parent because she allowed the kids to have visitation with the dad, and the dad wasn't in the home at that time, right? And so your argument is that's part of her battered parent syndrome, right?
Yes, Your Honor.
And then finally, the termination occurred based on the fact that they say she failed to protect the children because she didn't file for a DVP sooner. So that goes back to your issue of she was manipulated and a battered parent. Plus, they argue that she's not a battered parent because taking the kids to visit with the dad after the DVP was entered is evidence that she's not a battered spouse, right?
Yes, Your Honor.
Now, let me ask you this. Petitions filed on May 30th of 2019, and she was terminated roughly 6 months later. Is that about right?
Yes, Your Honor.
What took place in that 6 months? Did she have any services at all provided to her?
Your Honor, I do not believe that she had services provided. The position, my understanding, is that the department, because the mother refused to stipulate to an adjudication, services were not provided to her, and that she was essentially to be drug screening and visiting without...
Did she do that?
Yes, Your Honor. Yes, I
How
believe.
many negative drug screens did she have in that 6 month period, if you know?
Your Honor, the number escapes me, but my understanding was that she did not have a single positive screen.
Okay, so during that 6 month period, she did not have a positive drug screen. Is there any allegation in the record that she refused to screen during this abuse? And I understand that they say she did back during the family court thing. I'm not talking about that. I'm talking about from May 30th on. Is there any indication that she refused to screen or didn't screen or missed screens?
I believe that there are allegations that she may have missed a few screens,
Okay.
but she still screened regularly, consistently, with a miss here. I don't want to completely absolve my client and say she was 100% perfect and lie to this court, but in general, my understanding of the record is that, yes, she was screening.
And she was screening and effectively screening negative, right?
Yes, Your Honor.
All right, so we get down to, now this is the other thing that bothers me. Upon the filing of an abuse and neglect petition, there's supposed to be a preliminary hearing in 10 days. Did that happen? I can go check the record if you don't, I mean, if you don't have it right at your hands, don't worry about it. But absent that, an adjudication is supposed to take place within 45 days, roughly 45 days from the date of the preliminary hearing. Is that right?
Yes, Your Honor.
Now, so if we're looking at 45 days, 10 days plus 45 days, let's call it 60 days. So that's June, July, should have been an adjudicatory hearing sometime at the end of July, 1st of August. Why are we looking at October before there's an adjudicatory hearing?
Well, Your Honor, before I answer that, may I answer your previous question?
Sure, I'm pounding you here, and I don't mean to do that. Go ahead.
I found the proper information that was filed on May 30th. A preliminary hearing was held on July 30th, and the adjudication was held on October 29th.
So the preliminary was 60 days after the filing of the petition, and the children were out of the home, right?
Yes, Your Honor. And Your Honor, I can't speak to the lower court's
Well, I understand.
docket handling.
I understand that, but the problem that we have here is that the whole process is designed in abuse and neglect cases. It's a rocket docket, and the reason it's a rocket docket is because of the issue of permanency for the children. And technically, the case is supposed to be over in no less than 12 months. If you give a couple of improvement periods in there, it's supposed to be over in roughly 12 months, the final resolution of the case. So we get down to October the 30th, and we have an adjudication. Was that also noticed as an adjudication and a dispositional?
I believe the disposition hearing took place on November 19th.
So he adjudicated her on October the 30th and had a dispositional hearing on November the what?
19th, Your Honor.
Yeah. How much testimony was taken in all those hearings?
At the adjudication hearing, the state called, I believe, 4 witnesses, Your Honor. And then at the disposition hearing, no testimony was presented. It was simply argument.
Yeah. Preliminary hearing, the transcript was 15 pages long. I can't set the case and name all the lawyers in 15 pages. The adjudicatory hearing was 55 pages long, the transcript. And the dispositional hearing was 10 pages long. And that's the typed transcript. It looks to me like there was not a lot of evidence taken in this case. Would you agree with that?
I agree, Your Honor. As I stated before, the sufficiency of the evidence in this case is, in my opinion, quite lacking.
Mm-hmm. That's all the questions I have.
Okay. I believe your time has expired. In order to give you some brief period of time for rebuttal, if we could move forward and hear from the respondents, please.
Thank you.
Mr. Chief Justice, and may it please the Court, John Maslin on behalf of the West Virginia Department of Health and Human Resources. There are 2 independent grounds for affirming the Circuit Court's order terminating Mother's parental rights here. First, the Circuit Court properly adjudicated Mother as an abusing parent for her use of methamphetamines. And second, the Circuit Court properly adjudicated Mother as an abusing parent for subjecting her children to domestic violence and failing to correct those conditions of abuse. And then the dispositional order was correct in terminating because mother failed to acknowledge the conditions of abuse or neglect or be able to correct those. First, on the timing to answer Justice Hutchinson's question. On June 13th, which was 15 days after the petition in this case was filed, there was a preliminary hearing scheduled. The record shows that preliminary hearing was continued. There's no explanation in the appendix that the petitioner provided for why that hearing was continued, but the preliminary hearing was scheduled for 2 weeks after the filing of the petition.
But there's no indication who continued it? The record doesn't show who asked for the continuance?
The record does not.
Okay.
We have a copy of the docket, and the docket does show that the preliminary hearing was scheduled for June 13th and was continued, and there's nothing in the record that says whether the petitioner, the father, or the department requested that continuance. Now, father was incarcerated federally at the time, and that might have played a role in the timing of these hearings because they did bring him in. He was there in person at the adjudicatory hearing from the federal prison. So they issued a writ, and they had to transport him to the Tucker County Courthouse for that adjudicatory hearing from federal prison. Let's turn to the drug abuse issue here. On May 14th, mother tested positive for methamphetamines. At that time, the family court ordered her to appear for drug testing twice a week. She failed to do that. She appeared on the 14th, and then page 8 of the adjudicatory hearing transcript says, the question from the prosecutor, did she comply with that order? The response, and this is again in October, no, I have not seen her since May 14th. From May 14th to the adjudicatory hearing at October 30th, she did not appear for drug testing a single time. Now, she did testify during her examination that she appeared in Fayette County 3 times for drug testing, and that is at page 46 of the adjudicatory hearing transcript, where she says she appeared 3 times in Fayette County and tested negative. But she was ordered to appear twice per week from May 29th, the time of the adjudicatory hearing, and then she started testing again in mid-September. And in mid-September, the evidence shows that she started testing negative. So for the 6 weeks between mid-September and the October 30th adjudicatory hearing, she did test negative. But this case is similar to In Re DJ, which this court decided in June of this year. In Re DJ, the parent tested positive for methamphetamines once, and then the parent failed to appear and be tested. This court found that that was sufficient evidence to adjudicate the parent as an abusing parent and to terminate the rights. Now, this wasn't brief, but the citation is 2020 Westlaw 3259627. So there's nothing different from this case than DJ with respect to a parent who tests positive for methamphetamines once and then refuses to appear and be tested from May 14th through mid-September. The circuit court made the proper inference that she was continuing to abuse drugs, or at least wasn't willing to recognize that she had used drugs. And at the October 30th adjudicatory hearing, she testified that she never used methamphetamines. She said she used a white powder maybe once in 2017. That still would not have been in her system. And so therefore, the circuit court properly adjudicated her on that grounds. And then properly terminated her on the grounds of the drug abuse, again, because she refused to acknowledge the conditions of abuse and neglect. In Re Timber M, this court clearly held that when a parent refuses to acknowledge the conditions of abuse and neglect, that they are unwilling and unable to correct those conditions of abuse and neglect, and termination of parental rights is appropriate. Because mother never acknowledged that she tested positive for methamphetamines, testified to the contrary at the October 30th adjudicatory hearing, the court properly terminated her parental rights on that ground. And this court's analysis can end there because that independent ground of adjudication and termination was appropriate. Let's move on
Counsel,
to...
before you move on to that, let me just ask on that question. One of the points I think that's in contention here is you're saying she did not admit to the drug use and therefore did not admit to the abuse and neglect. But one of the questions is, and I would ask you to respond, is the use of drugs of illegal drugs by a parent, is that in and of itself abuse and neglect, or does there need to be some nexus between that use and an effect on the children that has to be shown?
There has to be some effect, and I think that the circuit court made a proper inference because of the type of drug that was at use here. It was methamphetamine. This was not marijuana or some other substance that doesn't have a significant impact on a parent's ability to properly parent their child, especially when, as here, father is currently federally incarcerated for dealing methamphetamine. He pled guilty to that earlier this year and is currently sitting in a federal prison waiting to be sentenced for dealing methamphetamine. And the fact that mother tested positive for meth and then refused to engage in drug testing thereafter, that clearly had an effect on the two children here. And so adjudication was proper and also termination.
So do you believe there, and I'm not trying to put words in your mouth, but I'm just trying to understand your argument, that certain use of controlled substances is basically in and of itself an indication of abuse and neglect?
I think that's correct, Your Honor. I think that if the evidence shows that a parent is using a hard drug such as methamphetamine, that impacts the children and inhibits their ability to parent their children and constitutes abuse. Because all that you have to show that a child is abused is that their mental, physical, or emotional health is threatened by the parent's activities. The parent's activities in using methamphetamine threatens the children's health, even if there is no impact that can be shown in this particular case. If the harm is threatened, that is sufficient under 49-1201 to adjudicate a parent as an abusing parent. Moving on to the domestic violence at issue in this case. There is no dispute that father abused mother in this case. Mother's testimony at the adjudicatory hearing was that when she was driving, father beat her unconscious. The caseworker testified that there was, quote, lots of severe domestic violence. The caseworker also testified that this mentally destroyed her. But then the caseworker went on to explain what mother did after the domestic violence occurred. As opposing counsel indicated, mother obtained a domestic violence protective abuse order. After that occurred, on Easter Monday, mother allowed the children to visit with father despite the family court's order that she was not to allow the children to have contact with father. Then, on page 15 of the adjudicatory hearing transcript, we see the caseworker testifying that mother engaged in text message exchanges and Facebook Messenger exchanges with father after the domestic violence protective order was entered. Mother testified to the contrary in her testimony. However, the circuit court explicitly found that testimony not credible. The caseworker testified that she saw the exchanges, and that is the key word, exchanges, that mother was engaging with father after entry of the domestic violence protective order. And so therefore, the circuit court found that mother was not a battered parent. Would it be easier if there were clearer language in the adjudicatory hearing? Yes, it would be. However, the implicit findings in the adjudicatory hearing when the circuit court adjudicated mother for subjecting these children to the domestic violence by the father was that she was an abusing parent and she failed to satisfy the definition of a battered parent under 49-1201 because of her continued contact with father and allowing the children to see father. The circuit court implicitly found that she was condoning the domestic violence. That factual finding is not clearly erroneous. There was plenty of evidence presented by both the caseworker and by mother's own testimony that she was a victim of domestic violence, but that she did not correct those conditions and instead continued to engage with father and allow father to have contact with the children. And mother admitted during her testimony at page 50 of the adjudicatory hearing transcript that this had a negative impact on the children. She said the children were properly fearful of their father because of the domestic violence towards mother. And so she said there's no question that these children are fearful of their father. And yet she let them go to the father's residence on Easter Monday and then continued to engage with father through Facebook Messenger and text messages. And so before he was federally incarcerated for dealing methamphetamine. So therefore, the evidence here supports the circuit court's implicit factual finding that mother was not a battered parent. But even if the circuit court erred and should have adjudicated mother as a battered parent, the circuit court's order should still be affirmed. I'm going to use the current code citations instead of the old code citations, but under 49-4-604D, there are two ways that a parent who is adjudicated as a battered parent can have their rights terminated. The first is under D6, where a parent's skills have been seriously impaired and the person has willfully refused or is presently unwilling or unable to cooperate in the development of a reasonable treatment plan. The other method is through the catch-all provision of 604D. D says that subparagraphs 1 to 5 are circumstances which show that a parent there's no reasonable likelihood that the conditions of neglect or abuse can be substantially corrected, but that list is not exclusive. Here, there was evidence that mother was unwilling to recognize the serious nature of the domestic violence, continued to allow children to have access to father, continued to contact father through Facebook Messenger and text messages. So therefore, even if the circuit court should have adjudicated her as a battered parent, termination was appropriate under 604D's catch-all provision. So therefore, there are two independent reasons to affirm in this case. First, there's the use of methamphetamine and the failure to appear for a single drug test between May and September. And even if you credit her testimony, she appeared only 3 times in Fayette County. And her failure to acknowledge that abuse was sufficient grounds for termination. Second, mother subjected the children to domestic violence from father. The circuit court properly declined to adjudicate her as a battered parent. But even if the circuit court should have adjudicated her as a battered parent, termination was appropriate under 604D's catch-all provision. For these reasons, this court should affirm the circuit court's order terminating mother's parental rights to the children.
Okay, thank you. We could now hear from the guardian ad litem.
Good morning, Heather Weiss, guardian ad litem. Justice Hutchison, to clarify, I'll call your attention to page 3 and 4 of my brief. My apologies for not supplementing an appendix, but the Department's counsel is correct. The preliminary hearing was scheduled on the 13th of June. It was continued to allow for the appointment of a special prosecutor to handle the proceedings. The Tucker County prosecuting attorney had a conflict, so there was a request made by him, put through to the Prosecutors Institute, and Randolph County was assigned to hear that case. In Tucker County, we have 2 judges that share the circuit between Mineral Grand and Tucker, as you're aware, and Judge Nelson, who is currently handling the abuse and neglect docket, comes over about once a month, and so the next available hearing date for that preliminary hearing was the 30th of July, at which time the DHHR worker testified and the judge found probable cause. The adjudicatory hearing was to have been held the 16th of September. However, there was some additional discovery issues from a recent CAC interview of the children, as well as the need to obtain a federal writ to secure the presence of the respondent father due to his incarceration on the pending drug charges. The adjudicatory hearing was also to have been held on October 15th. However, the writ was denied by the federal court because the respondent father was to appear in federal court that same date. And so that is the reason the adjudicatory hearing was not held till the 29th of October. So I just wanted to spread upon, even though it is not in your record, those orders could have been provided to you, and that is my oversight for not doing that had I anticipated it being an issue of the court. My argument is based on the fact that any possible defense that the appellant would have to predicate her status as a battered spouse would call this court to wholly set aside any substantiation for her substance abuse. The definition of a battered spouse, as the court is familiar with and laid upon the record in this case, requires that her victimization as a battered spouse and her adjudication, while she didn't condone it, she was wholly unable to stop it based on being a victim in and of itself. While it's true that the appellant was a victim of domestic violence, the facts of this case do not establish that she was unable to stop the abuse and neglect because of the domestic violence at issue. On the contrary, at the time of the filing of this petition, she had separated from her perpetrator, was living separate and apart at removal, had obtained the protective order which was alleged to have been violated, and had even absconded to, as she testified on the record, Fayette County with the children.
When was that DVP issued?
The divorce was filed, it's my understanding, Your Honor, let me get my dates here. The divorce was filed November of 2018 in Tucker County. She alleges separation officially the month prior in October, and the protective order was issued November of 2018, I believe, around the time of the filing of the divorce.
Was that a 6-month or a 1 year? Do you know?
I believe it was a 1 year. I believe the testimony on the record was it was to expire November of 2019.
Okay, thanks.
The evidence, as the court is aware, while it is true that she was a victim, the record shows that she also engaged in her own violence, her own abuse and neglect against the children. And the record shows sufficient evidence of her own abusive and neglectful parenting in regard to her substance abuse. To hold out that she only had one screen and to say that the only evidence of that presented was the May 14th of 2019 screen, where she was negative for her field test of her urine sample, but later confirmed by a blood draw, as I'll draw the attention to the court to, which confirmed the presence of methamphetamine and amphetamine. To say that she only had one screen and that it fails to be sufficient evidence of her substance abuse problem causes the court to wholly disregard the fact that she was failing to comply with the family court's order that she submit to drug screens twice a week on Mondays and Thursdays, that she failed to cooperate with the guardian ad litem in the underlying family court proceeding, giving the court and the guardian ad litem out of family court serious concerns that this was a remand under the court's jurisdiction set out under West Virginia Code 494302, a 96-hour remand of the children into the department's custody. This was the family court judge's start of this case because of her concerns with the mother's failure to cooperate with the screens, also coupled with the fact that her husband was incarcerated for conspiracy and distribution of methamphetamine charges.
Counsel, your time has pretty much expired, so if you could bring your...
Yes, Your Honor. So for purposes of the fact that, just briefly, her status of never accepting responsibility, she was adamant that she did not use despite the screen to the contrary. Her own husband acknowledged in testimony was permitted that she used drugs, and she did so while exercising care, custody, and control of the children. And we know that methamphetamine and its side effects in and of itself make it inherently dangerous to parent a child. So she had care, custody, and control of her children during this time, and the court had sufficient evidence to adjudicate her wholly outside of her status as a victim of domestic violence, and her failure to accept responsibility rendered an improvement period in exercise and futility at the expense of a child, and the court was correct in denying her motion and terminating her parental rights.
Let me ask one question, Chief, if you would. I apologize for eating into the time. In dealing with the children, what kind of a bond do you see that those children may or may not have with the petitioner? I mean, is there a significant bond there or no?
Well, the children were 4 and 8, Your Honor, so I'm not disputing the fact that there was a significant bond. And the testimony of the children, for purposes of the investigation by the department, centered primarily around the fear of their father and the domestic violence perpetrated against him. But I'm not going to stand before this court and deny that she does not have a bond with her children.
All right, thanks.
All right, thank you.
Thank you.
Counsel, we will give you a brief period of rebuttal. I think you used pretty much your time, but because there were several questions, the court will give you just a few minutes to wrap up.
I'll be very brief, Your Honor. Thank you. Just 3 quick points. First, it's been brought up, this failure to acknowledge any issues. Again, I think that's part of the battered spouse syndrome, and that it's not something that goes away right away. She did take a step for the DV. Just because she allowed contact after doesn't mean that all of a sudden her battered spouse status is gone because she took one step. It's like an addiction. It's something you have to work through and work through. Second, I would disagree with counsel's position that certain drugs should be classified, use of certain drugs should be classified or sufficient as abuse and neglect in and of itself. I mean, that creates a slippery slope where this court would have to go through each and every drug, look at every circumstance, and define in what circumstance one use is sufficient or what drug is sufficient, because there's no evidence, again, that the parenting was impacted in the mother's opinion. And finally, as was questioned and mentioned earlier, the lower court judge himself stated, "I have no doubt that the petitioner is a battered spouse." That's on the record at the disposition hearing. Your Honor, I think that's sufficient in and of itself. I don't think the drug use evidence was sufficient for the reasons stated, and the fact that the lower court judge acknowledged that she was a battered spouse is sufficient for a remand in this case, and that's what we're asking for. Thank you.
All right, thank you. Thank you to each of the counsel, and thank you for participating in the first day back in person here, and this case will be submitted.
The next case for oral argument is also being presented under Rule 20. State of West Virginia versus Dean E. Gamble Sr., docket number 18-0654, an appeal from the Circuit Court of Fayette County. And although Justice Workman is not here in the courtroom today, she is viewing and listening, and she will participate in the decision and opinion in this case. I will remind counsel that you each have 20 minutes to present your argument to the court. And counsel for the petitioner, you may proceed.
Morning.
Afternoon, Justices. Let me slip this up. We're able to take masks off, correct?
Yes, you may, while you're pursuing your argument, you may remove them.
Thing is toasty. Mr. Chief Justice, Justices of the Supreme Court, may it please the Court, my name is Nigel Jeffries. I'm here on behalf of Dean Gamble Sr. I want to state at the outset that my remarks will be confined specifically to the multiple enhancement assignment of error. The other assignments of error that were asserted under Rule 10C, 10B of the Rules of Appellate Procedure, and they have been supplementally briefed pro se by the petitioner.
Well, let me ask you, counsel, since you've kind of characterized what your argument will be focused on, the enhancement, was there ever a timely notice of appeal filed to the sentencing order from May of 2018?
Your Honor, I did not represent Mr. Gamble below, but we cannot argue that there was. There was no notice of appeal done within 30 days. The notice of appeal was filed about 2 months after the sentencing order had been entered. So we can't argue to this court that it was timely filed. However, what we would argue to this court is it has essentially 4 options, I think, for still granting relief on the merits of this case. The first being...
Well, let me ask you just to make sure.
Yes, Your Honor.
So, yes, it was May 29th of 2018 was the original sentencing order. The notice of appeal was July 28th, 2018. But in that, it referenced the June 22, which is the denial of the Rule 35B motion. But this court issued its order in July of 2018 specifically stating that the appeal being considered by this court was exclusively the Rule 35B denial.
Your Honor, there's also a conflicting order from this court on May 21st that states, on November 13th, Petitioner Dean Gamble perfected the appeal from an order of the Circuit Court entered on May 29th, 2018, with the filing of Petitioner's brief and appendix. That was the sentencing order herein. Regardless, I think that this court can still apply the plain error doctrine, even if this is, assuming for argument's sake, was not a timely submission. This court can still apply the plain error doctrine to a Rule 35B motion. And the case that I rely on for that is State v. Griffey, which is 229 West Virginia 171. That case concerned an 11E1C plea that was supposed to be binding on the court, and under the rule, the petitioner is able to withdraw that plea should that sentence not be granted or imposed by the court. The court did not so inform the petitioner, the defendant, that he was able to withdraw that plea if he did not impose that sentence. There was no direct appeal filed. What was filed was a Rule 35B motion to reduce, and this court still found plain error. So I believe that this court can still apply the plain error doctrine, even if it were to find that this was not a timely filed notice of appeal. Now, I will say that this court also, I believe, has the inherent authority to find good cause. Mr. Gamble, which is in the record, appealed essentially 2 months after the sentencing order was entered. Unfortunately, his counsel did not file a notice on his behalf, and in fact, the court below permitted counsel to withdraw and said that Mr. Gamble, in the order, did not have grounds for an appeal. Obviously, that's not for the trial court to decide. That's for this court to decide. And that's the whole purpose of Rule 10C, 10B, is even if you don't believe that there is a good faith basis for the appeal, you still have to file it. So I would ask this court if they can find good cause for the late submission of the notice of appeal in the alternative. Also, jurisdiction, I believe, can be argued at any point. And as the court in State ex rel Ringer v. Bowles stated, habitual criminal proceedings provided for enhanced or additional punishment on proof of one or more prior convictions are wholly statutory. In such proceedings, a court has no inherent or common law power or jurisdiction. Being in derogation of the common law, such statutes are generally held to require a strict construction in favor of the prisoner. This court has consistently held that the habitual criminal statutes of this state are mandatory and jurisdictional. So this court could also find that the court had no jurisdiction to impose the second enhancement, rendering it null and void, remanding it back to the circuit court to remove that enhancement. Moving on to the substance of the argument, there's no express language. It was plain error here for the court to impose 2 separate enhancements on a conviction rendered in the same day in the same proceeding. There is no express language stated in the statute for such. The state argues that it is permissible because it's not explicitly prohibited, but that's not the standard of the court. The standard of the court on sentence enhancement statutes, because they are in derogation of the common law, is that they have to be strictly construed and the language must be expressed. And there is no express language in that statute for that proposition. I would state that the 611118, which is a general recidivist / enhancement statute, reads strikingly similar to the statute that we're dealing with here today, which is 60A4408. Neither have express language, so I'm asking this court to apply the holdings in Turner and Hutchinson, which both stated that absent that express language that the court is without the authority to impose separate enhancements on convictions rendered in the same day. So I'm asking the court to render at least one of those enhancements against Mr. Gamble null and void. If you look at the language of 60A4408, the legislature only contemplated that this statute would apply to one conviction, not multiple convictions. I'm looking specifically at subsection B of the statute, which states, for purposes of this section, an offense is considered a second or subsequent offense if prior to his conviction of the offense, not offenses, the offender has at any time been convicted under this chapter or under any statute of the United States, of any state relating to narcotic drugs, marijuana, depressants, stimulants, or hallucinogenic drugs. Now, the state argues that any person convicted of a second or subsequent offense means that any subsequent offense can be used. Therefore, the legislature permitted multiple enhancements for convictions rendered on the same date. I would argue that that is just a drafter's way of, rather than having to say that any second offense, third offense, fourth offense, fifth, sixth, it's just a drafter's way of making it easy. The legislature had full knowledge of this court's precedent when it drafted the drug recidivist statute, which was drafted in 1971. The original general recidivist statute of this state was drafted in, I believe, 1939. And it's been this court's jurisprudence that it must be expressly stated in the statute that multiple convictions may be separately enhanced for convictions rendered on the same day in the same proceeding. And last, that even if assuming for argument's sake that the statute is ambiguous, the rule of lenity applies. It's a penal statute, it must be construed against the state and in favor of the defendant. If there are no further questions, I would...
Just one, if I could ask, just, it seems like, if I'm correct, that your argument basically is that the general recidivism statute doesn't allow you to use a second, like if you're convicted of two crimes on the same day, you can't say, well, one of them was a prior crime and the second one is the one that brings forth the recidivism charge. But that's not really what we're doing here, is it? Because you're not saying that the one that provides a recidivism that in most cases is several years prior. In this case, both of them are still looking back to prior crimes that are several years ago. So there was an opportunity there in the current situation, was there not, for your client to have sort of changed his ways and found the area of his ways and not recommitted this offense. Whereas in the other situation we were talking about, you're kind of comparing, there isn't that opportunity because there's no time period in between. So because the fact there's a time period, doesn't that kind of undermine your argument?
It does. So the recidivist statute works both ways. If I pled guilty first time I've ever been charged, convicted of anything, let's say I plead guilty to two separate felony offenses, grand larceny and malicious wounding. Those two can't be used to enhance each other, but separately, at least separately, if I get convicted later on, and let's say I plead to three separate charges on the same day, only one of those convictions can be enhanced. You can't enhance all three of those convictions. So essentially, for example, shoplifting or domestic battery. If you are picked up and charged with shoplifting on two separate days, but you plea in the same day, you're not then charged later on with third offense shoplifting. You can only be charged with second. And so for this court's jurisprudence, no, you cannot enhance, you cannot separately enhance each charge you've been convicted of on the same date in the same proceeding. But alternatively, for example, let's say somebody's charged and convicted of malicious wounding, first-degree murder, and with mercy or sexual assault, and they have 2 priors. So the state moves to recidivize them for life. Well, the court can only impose the life sentence on one of those. They can't lump everything together and impose a recidivist statute, and separately they can't impose 2 separate recidivist statutes. It can only be on one of them, and the purpose is because it's against it's derogation of the common law, and since it's not set forth in the statute that says that multiple offenses, regardless of when the prior was, multiple offenses cannot be separately enhanced if they are entered into on the same day. Convictions entered into on the same day are considered one conviction. For the recidivist statute, for other enhancement statutes, like I said, shoplifting, domestic battery, et cetera, et cetera. So I don't think it makes much difference that that he had a prior drug conviction, because that prior drug conviction, we're not arguing they couldn't enhance it. What we're saying is they couldn't take that and enhance both of them. Now, if he would have pled guilty on the very next day and been convicted, then they could have enhanced both of them because it's not in the same date in the same proceeding. But since they were, then the state can't come, and well, actually it's not even the state here, it's the court. The court can't then separately enhance both of those, because for purposes of the recidivist statute, it is only considered one conviction.
All right.
Thank you.
Thank you. Can I hear from the respondent, please?
Do you want me to take this down really quick? Are you sure?
May it please the court, my name is Laura Bissett. I'm an Assistant Attorney General here today on behalf of the state of West Virginia. In its scheduling order of July 30th, 2018, just as you pointed out, Justice Jenkins, this court very aptly recognized that what we are here for today is an appeal of a Rule 35B motion for reduction of sentence. Clearly, as Mr. Jeffries acknowledged, there was no direct appeal filed in this case in a timely fashion. The final sentencing order was entered in May of 2018. The notice of intent to appeal was filed in July of 2018, well outside of that 30-day window for filing a direct appeal. And in the meantime, we had this Rule 35B motion for reduction of sentence, where the final order came in on June 22nd of 2018. In fact, in his notice of appeal, Mr. Gamble himself recognized that he was appealing the Rule 35B order and not the sentencing order. So with that said, and because we are here today on a Rule 35B motion for appeal, this court has pointed out in Syllabus Point 2 of State v. Markham that Rule 35B is not a mechanism by which defendants may challenge the validity of their sentencing. Rather, as the court recognized in State v. Head, a Rule 35B motion is essentially a plea for leniency from a presumptively valid conviction. Per the Markham Court, challenges to convictions on the validity of a sentence must be made through a timely filed direct appeal. And unfortunately for Mr. Gamble, that did not happen here. So, given that why we are here today is the denial of the Rule 35B motion for reduction of sentence, the court reviews that order in a 3-part analysis. First of all, the court reviews the lower court's decision under an abuse of discretion standard. The findings of fact are reviewed for clear error, and of course, questions of law are reviewed de novo. Petitioner's motion in this case was very truly and very purely an act of him throwing himself on the mercy of the court. The court had just sentenced this man scarcely a month before, and the court recalled that the very reasons why it didn't grant him an alternative sentence in the first place is because this is a man with a 42-year criminal history. He's committed 23 crimes across 3 states in that time. And the court found then that he was not likely to be a successful candidate for an alternative sentence. In this case, I believe his last request at the Rule 35B hearing was that he would like to go to drug rehabilitation. The court found instead that he was likely to commit another crime. And so the court denied that Rule 35B motion. With all of that said, this court cannot say that the circuit court abused its discretion then in denying that Rule 35B motion. And the record certainly bears out that the court did not findings of fact, So that is where this court's analysis of this case should end. But obviously, we're here today and we're arguing. Mr. Jeffries has argued basically that he is challenging the validity of the sentence and whether in fact the court could Mr. Gamble's sentence on both of his convictions for his 2018 convictions of delivery of a controlled substance.
Before you actually go into that, can I just ask a question relating to your first point there, that was there any point at all before the circuit court in relation to the 35B motion that the petitioner raised the issue of the enhancement being used twice? Was that at all?
Your Honor, it is not my understanding that was part of his. It is my understanding from the record there was no actual hearing. As I said, it was very close in time to the actual sentencing, so the court did not feel that it was necessary to have a hearing. So there was no hearing, and it is my understanding from the record that the motion itself was grounded in a pure plea to the court to please have mercy on him because he has poor health, he has substance abuse issues, and basically he was, as I said earlier, just throwing himself on the mercy of the court. Please can't I have a reduced sentence instead? But I don't believe that he did raise that as an issue in that Rule 35B motion.
All right, thank you.
And the sequence of events, didn't we have a pro se litigant here that his appointment of counsel came later, and I kind of derived from petitioner's argument that when the court allowed for the appointment of counsel and that was recognized in the language from this court's order, he's trying to bootstrap that was somewhat vague in allowing a notice of appeal to be filed, and that he used that opportunity months and months later upon the filing of the notice of the appointment of counsel to open back up essentially the original May 29th, 2018 order appeal.
Yes, and certainly Mr. Gamble is not unsavvy about the judicial system. As I mentioned, he has a lengthy history in the judicial system. He knows what his rights are. He's been through this many times. He has filed many petitions before this court and other courts. Even with a lapse of counsel in there somewhere, obviously he knew as soon as that Rule 35 motion was denied that he needed to file a petition for appeal, a notice of appeal in that case. I would think that he would have had that same awareness previously. And he mentioned that the court made that there was no merit in an appeal. Certainly, Mr. Gamble doesn't agree with that. I doubt that he ever has. So,
counsel, let me ask you one question. From petitioner's argument, he basically, in my interpretation, concedes there was not a timely appeal filed to the original sentencing order, and he's focused on plain error. And you appropriately, I think, started off your argument talking about the standard of review relating to a denial of a reduction under 35B. Since he, again, in my opinion, is putting his eggs in the plain error basket, can you, before you talk about the substance, can you go through your opinion of the four-part test for plain error and why that I assume your position would be that the plain error doctrine should not apply here?
Right, and that is the state's position. The state feels that there was no error in this case at all. The courts, and I will argue this a little bit farther in a moment, but the court's sentencing in this case was squarely within the confines of the statute, which in this case is 60A4408. So there was no error in the court pronouncing the sentence that it did. I don't know that anyone could argue that when you're sending someone to prison, there are substantial rights involved. However, The alternative for Mr. Gamble here was for him to have been charged as a recidivist, at which point he would have been convicted. He cannot deny that he has a history, a felon history, and that he would have been convicted under the recidivist statute, and he would be spending life in prison now. So certainly it seems that 5 to 25 years in prison is less of an affront to his rights than a life imprisonment would be. The state would also argue that there's no serious impunity to the reputation of the court. Nobody would argue here that a man with a 42-year criminal history, 23 convictions that span everything from forgery on the lesser end to sexual abuse and larceny, armed robbery on the farther end, that man, nobody would question, deserves to spend some time in jail. And I don't think then that a 5 to 25-year prison sentence in any way impugns the fairness, the integrity, or the public reputation of the court.
Ms. Bissett, let me ask you a question, and I'm going to go a little bit out of what you've been talking about here. The judge made a finding, look, everything's been done correctly. You got no grounds for an appeal. Counsel, you're dismissed. Now, what's going to happen? We rule against the petitioner in this case and adopt your position. What's going to prevent this defendant from filing a habeas action that says he had ineffective assistance of counsel because counsel didn't file an appeal for him when he thought he should have? And counsel left him hanging. In fact, he had to file his own pro se 35B motion, which, you know, has some grounds, but the issue with the 35B motion is, according to the case law, you're supposed to look at a substantial change of circumstance from the time of the sentencing to the time of the filing of the 35B motion, which must be filed within 120 days. Mm-hmm. So there's got to be some substantial change of circumstance. Well, his substantial change of circumstance apparently is, oops, I think I've got an appealable issue here, and I want to get my sentence reduced, effectively asking the court to do what his counsel is now asking us to do and say you can't double up two of them. That's essentially what he was saying. So are we going to get faced, are we going to do the right thing here and rule in the state's favor and then be dealing with a habeas action whereby we might be forced to send him back to be resentenced so he could have an appeal on that issue? Why don't we just send him back, have him resentenced, and order counsel to file an appeal?
Well, let me break that down a little bit. First of all, I don't believe that he did raise in the Rule 35B motion that he felt that his sentence was invalid. He questioned whether he should have been granted an alternative sentence just based on his status in life.
But that was pro se, correct?
But that was, I do believe that was pro se.
Okay.
However, going back to the habeas issue, I'm sure you're well aware that nothing prevents anyone from filing a habeas. And most of the time, once we have a criminal appeal that goes through, it doesn't come out in favor, we almost always get a habeas on the other side of that. So I don't know how we can prevent that. Certainly, he raises an ineffective assistance of counsel in his supplemental, an ineffective assistance of counsel claim in his supplemental brief. So it does feel like that's probably something that he's working on already. But there are some tricky parts about sending this back for resentencing. The plea agreement was written such that if Mr. Gamble challenged his sentence, then
it's done.
And it got back, then we're done here and the parties are reset to their original positions, in which case Mr. Gamble's original position is a multi-time felon, and the state actually wanted to file that recidivist information under 61-1119 and was talked out of it by the defense after they had negotiated the plea agreement. So it stands to reason that the state would probably file that in this case if it was sent back, and then Mr. Gamble would be facing a life imprisonment, where here again, we have another habeas, I'm sure. So I don't really know how to address that. I think certainly there will be a habeas, but I suppose that's job security for me.
But
so.
thank God for the people that sue my clients, and that defense lawyer's mantra. But my point is, the point I'm trying to make is that we're going to have to address this issue at some point in time. And I guess this may not be the case, because if Mr. Gamble, if we grant him some relief up here today, Mr. Gamble's going back down, and then the agreement says all bets are off.
Right, right. And, you know, certainly the state's position in this case is that 60A4408 is a different animal from 611118. This court has recognized that themselves. This court has repeatedly held or upheld or refused to review sentences just like Mr. Gamble's, where under 60A4408, separate sentences for separate convictions rendered on the same day were enhanced. This court has had two significant appeals from habeas corpus petitions, as a matter of fact. The first being State Ex Rel King versus Yalapi. That's a 2012 case in which this court heard the appeal of Mr. King's denial of his petition for writ of habeas corpus. This court specifically pointed out in that opinion that it had refused to hear Mr. King's 2008 appeal of his conviction, and assumedly his sentence as well, the double enhancement. And this court affirmed the lower court's finding that, in fact, Mr. King's Eighth Amendment rights had not been violated when both of his sentences for delivery of a controlled substance were enhanced under 60A4408. Then, 3 years later, in Lester v. Plumlee, another appeal of a habeas corpus petition, this court again upheld the lower court's finding that there was no need for a writ of habeas corpus, where Mr. Lester had also been sentenced to multiple sentence enhancements under 60A4408. And this court specifically pointed to State v. Goodnight in finding that sentences imposed within statutory limits and not based on an impermissible factor are not subject to appellate review. So this court has already recognized that 60A4408, sentencing under that provision that allows for double enhancement, is not reviewable by this court. The court has further distinguished 60A4408 from 611118 in cases like State Ex Rel Day versus McBride, where this court found that there were many important distinctions between the two statutes, not the least of which is that 60A4408 calls for a discretionary and a far lesser penalty for enhancement of recidivist criminals than 611118, which is a mandatory punishment imposed by the legislature on the courts. In Mr. Gamble's case, that would have been a lifetime imprisonment. So because we have a lesser infringement on the freedom of a defendant who is sentenced under 60A4408, then certainly the protections afforded under Turner and Hutchinson that Mr. Jeffries discussed earlier are not afforded to petitioners under 60A4408. In fact, in State v. Rutherford, this court recognized the procedural safeguards put in place in the general recidivist statute are not considered constitutional imperatives under the enhancement of 60A4408. The other difference between 60A4408 and 611118 is that while 60A4408 does not expressly allow a court to enhance multiple sentences in the same proceeding, it does curtail other double enhancements. In particular, it curtails double enhancement under 60A4406, which is the part of the statute that deals with conviction where a person sells to a minor, or where a person sells within 1,000 feet of a school or within 200 feet of a library. That particular statute has an enhanced sentence already, and the legislature recognized that and said, okay, if you're going to enhance a sentence under 60A4408 for a second or subsequent offense, a second offense or a subsequent offense, then that's fine as long as you haven't already enhanced a sentence under 60A4406. Certainly then it seems to follow that if the legislature had further restrict double enhancement under 60A4408, it would have and could have said so, but it did not. And so one must presume that the legislature did not intend to further restrict double enhancements under that code provision. So the court did act well within its statutory limits in enhancing both of Mr. Gamble's sentences. And so then there was no plain error in this case. Moreover, there was no abuse of discretion in denying the Rule 35B motion for reduction of sentence. Again, the court had very good reasons, which were all laid out very clearly in the sentencing hearing and in the sentencing order. This man is a career criminal. He is not a good candidate for an alternative sentence, and therefore the state would ask that this court affirm the lower court's order in the Rule 35B motion for reduction of sentence. And I would just say, I know that Mr. Jeffries didn't address the issues contained in the supplemental brief, but the state would remind the justices that we did address those in our responsive brief, and we will rest on our brief in that matter.
Thank you.
Any other questions? Thank you.
Thank you.
The petitioner has any brief rebuttal? No. All right. If not, then this case will be submitted. Thank you for participating in our first day back.
Yeah.
We miss shaking hands.
Elbows.
Thank you.
Guess I better take that one too.